Hello?
Hi, Thelma, it's me. We've got a problem. I was fired today.
What do you mean you were fired? You just got that plaque as Salesman of the Year. Your boss said you were one of his best people. How can they fire you?
Well, I don't know. I guess they want to hire younger people who aren't going to retire in a couple years. I got a severance check, but I don't know how we're going to make it. Who'd hire me at my age?
Well, there must be something we can do. You come on home and I'll call Sue's husband. He's a lawyer. We'll figure this out.
This may have happened to you or someone you know. Have you ever been passed up for a promotion when you thought you were the better qualified candidate? Perhaps you've been asked a question you found offensive in the middle of a job interview, or maybe you've been injured on the job. At any one of these times, you may have wondered about your legal rights in these and other job-related situations. The good news is that you're protected by a number of state and federal laws. The bad news is that these laws can be complicated, and it may not always be self-evident why some laws protect you while others don't. On this tape, you'll find out about your basic rights in the workplace. You'll be better prepared to ask the right questions and save yourself both time and money. Much of the material can be difficult to understand and somewhat confusing the first time you hear it. While it's recommended that you listen to all the tapes in this program several times in order to master the material, this topic needs special attention. That's why you'll want to get advice and assistance from a qualified attorney whenever you're faced with a serious legal problem regarding your employment. Wading through the maze of federal and state laws and regulations isn't something for the do-it-yourselfer. Now, here's Judge Wapner.
Let's begin by discussing the role of unions and collective bargaining agreements in the workplace. The National Labor Relations Act, or NLRA, is a federal law which grants private workers the right to bargain collectively. The assumption is that workers bargaining together can secure greater benefits than workers bargaining alone. Of course, not everyone believes that the extra cost associated with unions is worth whatever additional leverage you may gain. Whether you should join a union or not depends on your particular situation.
Judge Wapner, the employers at the plant where I work aren't unionized. If I circulate a petition to have a union represent us, can I be fired?
Generally not. If you're covered by state or federal law, your employer can't intimidate you or other pro-union employees by threatening to fire you. However, the NLRA doesn't apply to all workers. For example, farm workers, managers, supervisors, and employees of small companies that do very little interstate business are not governed by the law. Some states, however, have laws similar to the NLRA, and these state laws often do apply to public workers and some private workers who aren't covered by the federal law. Of course, employees who aren't covered by these laws can still bargain collectively if they choose to. The problem is that their employers can fire them for doing it, and they have no legal protection. The laws governing unions, union interaction with members, and union interaction with employers can be quite complicated and difficult to understand. To give you an example, if you're protected under the NLRA, you have the right to strike. However, your strike must be a legal one. Certain kinds of strikes, such as those that aren't authorized by your union or that violate a no-strike clause in your union contract, are considered illegal. Here are a few things to remember about strikes.
1. You're not entitled to wages for the time you're out on strike. In most states, you're also not entitled to unemployment benefits.
2. Picketing is allowed if it's done in small groups of workers, but picketing must be done peacefully, and in most cases it must not continue for more than 30 days.
3. Striking workers may not block the entrance to a plant, destroy property, or make threats. If property is damaged during a strike, individual members and the union itself may be held liable.
4. An employer is legally prohibited from discriminating against employees while they're lawfully out on strike or after they've returned to work.
5. If the strike was called to protest unfair labor practices, the striking workers are entitled to be reinstated in their old jobs. even if replacements have been hired during the course of the strike.
Remember, job reinstatement only applies to workers striking for unfair labor practices. Workers who strike for economic reasons, such as higher pay, aren't entitled to get their jobs back. Furthermore, if you participate in an illegal strike, you will lose your protection of the labor laws that safeguard strikers.
If you have specific questions about your rights in this area, you should contact the National Labor Relations Board or consult an experienced labor lawyer. For the purposes of this discussion, just keep in mind that while you may enjoy additional rights, you'll also incur additional responsibilities under the terms of a collective bargaining agreement. Obviously, since we can't possibly know the specifics of your particular agreement, we wouldn't attempt to do more than generalize. You should ask your union representative for a description of any additional rights you may be entitled to. Discrimination is a fact of life in the minds of many job seekers and workers. Some is real and some is imagined. The question is, what kind of employer discrimination is unlawful?
As you may have guessed, that depends. The bulk of discrimination law is the result of legislation passed by Congress. These laws are based on the idea that people should be hired, fired, and promoted solely on the basis of their abilities. The anti-discrimination laws prohibit employers with 15 or more employees from making such decisions on the basis of race, color, national origin, sex, religious beliefs, or disability. Most states have passed laws that apply these same standards to companies with less than the federally required number of workers. The result of this is that anti-discrimination law is largely the same for all of us. Collective bargaining agreements and private employment contracts may also broaden the definition of discrimination and expand the kinds of conduct that will be considered illegal. In other words, while none of these sources can reduce the definition of illegal discrimination as it's contained in the federal laws, they can and sometimes do expand that definition. Federal and state laws prohibit employers from making hiring, firing, promotion, and salary decisions on the basis of an applicant's or an employee's race, color, national origin, gender, religious beliefs, or age. It's important to note that discrimination in any of these areas doesn't have to be intentional to be illegal. If the effect of an employer's hiring or promotion practice is discriminatory, that practice is illegal. The only exception to this prohibition is if the employer can show that being of a certain race, color, national origin, gender, religious belief, or age is a bona fide qualification for a job. This means that successful performance of the job requires a particular attribute. A matron at a woman's shelter needs to be female. Church members looking for a pastor will require that the person applying be of their same denomination. And commercial airline pilots can be required to retire at age 60, since statistics indicate that older pilots may experience more accidents than younger ones. However, this kind of lawful discrimination is relatively rare. Specific job requirements are often smokescreens for illegitimate discrimination. Let's say an employer sets unnecessary height and weight requirements which discriminate against women. If the requirements discriminate against a protected group of people and are not truly necessary for and related to job performance, then they constitute illegal discrimination.
I was fired because my boss said my work performance wasn't up to his standards. I'd been at the company for 15 years and was just about to become fully vested in a profit-sharing plan. Now I have nothing, and my replacement is young enough to be my son. I feel like I've been discriminated against, but I'm not sure I have a case.
Discrimination often isn't that obvious. While on the surface it would appear your employer had a legal reason to fire you, There may be extenuating circumstances. Discrimination happens more than we'd like to believe. Let's assume that you're over the age of 40. You learn that other employees, all of whom are under 40, had performed at your level on similar assignments, but were not fired for it. With this evidence, you could show that your age, not your work performance, was the real reason you were fired. Courts are suspicious when employees aren't all treated the same way. Several years ago, there was an interesting age discrimination case between a 47-year-old man and the candy company he'd been employed by for over 22 years. He had just become a shift manager with a salary of $71,000 when the company introduced a policy of voluntary separation. Even though the company offered the man $40,000 to accept the separation, he refused it. He knew that his pension benefits would have been worth significantly more 3 years later when he'd completed 25 years with the company. The company fired him. He brought suit claiming willful age discrimination. The court agreed with his claim and awarded the employee over $500,000.
Judge Wapner, I'm 62 years old, and my employer wants to force me to retire because of my age. Do I have any rights that could protect me?
Yes, you do. Under the Federal Age Discrimination in Employment Act, companies with more than 20 employees cannot set a mandatory retirement age. The only instances in which exceptions are made are those in which your age is of critical importance to the job you're doing. If your company has less than 20 employees, you may still be protected by state legislation which prohibits mandatory retirement.
Judge Wapner, I went on a job interview and the manager told me I had to take a lie detector test before I would get the job. Is this legal?
It probably isn't. Under the Federal Employee Polygraph Protection Act, the use of lie detector type tests are severely restricted for most employers. The use of other psychological stress testing devices is also prohibited. Any employer who violates this law can be subject to $10,000 in penalties for each violation, and you may be able to sue the employer for civil damages.
My boss told me to do something illegal. When I refused to do it, he fired me. Do I have any recourse?
In most cases, you could successfully sue your employer since he dismissed you for refusing to break the law. The court would view the employer's action as a violation of public policy and probably award you damages.
If you're one of the 43 million Americans with a physical or mental disability, you should be aware of an important law that was passed in 1990, the Americans with Disabilities Act. This law prohibits employers from discriminating against a disabled person in his place of work. For example, if you're disabled, your employer can't decide to pay you less or give you less vacation time than those who aren't disabled. Your employer is also required to provide reasonable accommodations to allow you to do your work effectively.
Depending on your disability, your employer may have to provide a bathroom that's accessible to you or a computer that you can use to perform word processing tasks.
I'm a painter, and I have a severe allergy to a specialized paint at my particular job site. What can I do?
Under the ADA, you'd probably qualify as disabled, and therefore your employer would have to agree to your request for a transfer to a new job location where this type of paint isn't used. The new law also prohibits employers from discriminating against disabled persons in hiring decisions. In some situations, of course, a person's disability may serve as a basis for denying him a job. This would be the case if a blind person applied for a job as a security guard. The disability would interfere with carrying out the job effectively. But if a person's disability isn't related to the qualification for the position, then the employer may not discriminate against him in the hiring process. A good example would be if a person in a wheelchair applies to be a research consultant. In most instances, there's very little about research that makes it necessary to walk. The new law also states that disabled Americans must be accommodated in public services. In other words, public buses and trains, buildings with long flights of stairs, library materials and other services provided by state and local governments or by organizations which cater to the public must be adapted to the requirements of disabled persons. This means that if you are confined to a wheelchair, you'll have better access to bathrooms in public restaurants. If you're hard of hearing, you'll be able to take advantage of library materials which accommodate your disability. If you suspect that you are being discriminated against by your employer or in your ability to use a public accommodation, contact a lawyer.
The hearing to confirm Clarence Thomas as a Supreme Court justice awakened the country to the issue of sexual harassment. The question of who was telling the truth competed with a secondary issue of women and occasionally men being harassed in the workplace. What may not be clear, even after several days of Senate hearings, is the legal definition. The question most often asked is, exactly what is sexual harassment?
As you understand by now, this definition may vary depending upon the laws and agreements that apply to you and your job. However, as you also probably understand, there's a core of law that's generally applicable to everybody. Additional state and local statutes, along with union and individual agreements, may expand this law, but they can't reduce it. The Equal Employment Opportunity Commission, or EEOC, is the federal agency that is responsible for prosecuting sexual harassment claims. This commission defines sexual harassment as, and I quote, any undesired verbal or physical conduct of a sexual nature that unreasonably interferes with the performance of your job or that creates an intimidating, hostile, or offensive working environment, end of quote. Perhaps the most typical example is a female employee who's harassed by her male boss or co-workers. But it's important to remember the law isn't limited to this one scenario. Both men and women can be sexually harassed, and the offender can be of the same or opposite sex as the victim. Certain offensive conduct is obviously sexual harassment. It's pretty easy to recognize when a boss touches a worker inappropriately or pressures an employee to submit to sexual advances in order to receive a raise, be promoted, or remain on the job. And when the behavior is this offensive, a single instance is enough to support the worker's claim.
I have evidence that my employer has been sexually harassing me, but I don't want to go to court and lose. Do I have a chance if I bring suit against my boss?
If you have a strong case and solid evidence, you have a very good chance of winning. For instance, there was a case in California in 1986. A 38-year-old waitress refused to wear a sexually suggestive outfit. She was transferred from a high-paying cocktail lounge position to the low-paying coffee shop. Then her employer fired her and claimed the decision was based on poor work performance. She claimed she was fired because she had rejected his sexual advances. The waitress sued for sexual harassment and received a judgment of several $100,000. Unfortunately, sexual harassment may be less clear if the behavior is restricted to offensive comments, jokes, suggestions, or looks. Single, isolated events such as these aren't usually considered sexual harassment. If you find yourself in this position, I advise you to make it known that such comments, jokes, looks, and suggestions are unwelcome, offensive, and make you feel uncomfortable. Keep a written record of this conversation to be used as evidence in case you do file a complaint. After you've made your feelings clear, then repeated instances can be sexual harassment. Even if you didn't necessarily verbalize your discomfort, these incidents can be sexual harassment if they're repeated often enough. Remember, if your boss, supervisor, or someone with authority over you is guilty of sexual harassment, then your employer may also be liable. This isn't true, however, if a co-worker sexually harasses you. In that instance, your employer generally won't be liable unless he participated in the behavior or knew of the harassment and failed to do anything about it.
I'm pretty sure I have a grievance against my employer, but I don't know what to do about it.
You need to act quickly. If you delay too long, you may lose the right to bring an action against your employer. The first thing you should do is to file a complaint with the local office of the Equal Employment Opportunity Commission. This has two advantages. First, if you have a claim under federal law, the commission will investigate it and may even decide to sue your employer on your behalf. You can call 1-800-555-1212, which is 800 information, for their current phone number. If the commission chooses not to sue, you may still file a private lawsuit. Second, if you don't have a claim under federal law, but you do have a claim under state law, the EEOC can refer you to a local agency that may be of help to you. If you belong to a union, you should also file a complaint with your union representative. You may have additional rights under the union's collective bargaining agreement. In any case, you should certainly consider discussing your situation with a lawyer who has experience in the field of labor and employment law. That person will be able to evaluate your claim and explain your rights and options.
If I filed a lawsuit and won, what could I get?
All right, let's say you were illegally fired, passed over for promotion, or demoted. You could either get your job back or receive money damages instead. You'd also receive back pay from the date of the discriminatory action. In addition, you may also be able to recover punitive damages, along with damages for emotional suffering and lost benefits. Punitive damages are money damages awarded to the plaintiff in order to punish the defendant for malicious, oppressive, or reckless conduct. Specific provisions in your union agreement or employment contract, which is private, may entitle you to additional benefits and awards. If your lawyer feels you have a solid case, you might be well advised to take it to court.
A lawsuit isn't always the answer. Take injuries, for example. You may think that you can sue your employer if you're injured on the job. After all, if you're injured by a product, you can sue the manufacturer of that product. If someone runs into you and you're injured, you generally can sue that person. This isn't true for work injuries, which are treated differently under the law. Generally, you may not sue your employer for a work-related injury. Instead, you and your family will be compensated for work-related injuries, diseases, and deaths under the workers' compensation laws of your state. These laws exist in every state of the Union. They require employers to purchase workers' compensation insurance for their employees. In return, the employers are basically guaranteed that they won't be sued if an employee is injured on the job. This reduces the possibility of high jury awards against them. Employees benefit because they're guaranteed at least some compensation if they're hurt at work.
Employees who can't work for a period of time because of a job-related injury are entitled to damage from the Workers' Compensation Fund. The amount they receive depends upon the nature, seriousness, and permanency of the injury, along with other factors like the length of time they're disabled and the amount of their salary. Hospitalization and the cost of medical care and rehabilitation will usually be covered as well. If a worker is killed in a job-related accident, workers' compensation will provide his dependents with death benefits as specified by state law. Unfortunately, the inevitable result of producing a product is that some workers will be injured on the job. Before workers' compensation, injured workers found it very difficult to receive payment for their injuries and lost wages. They could sue, but for a number of reasons, they often lost or received very little in the way of damages. Workers' compensation laws were created in an effort to compensate injured workers without exposing them to the costs, delays, and uncertainties of the courtroom. The expense is passed on to the public in the price of the company's products or services. In this way, each of us ends up paying for the hidden costs of what we buy.
I don't think that the laws are all that fair. My father was crippled by an accident at a small tool and die shop, and he hardly got anything. He and Mom can't live on what he was awarded.
People have mixed opinions about the effect of workers' compensation laws. Fairly minor injuries usually are handled quite well, but some people feel that very serious injuries are often undercompensated. A little later, we'll discuss what you can do if you feel that the maximum award available under workers' compensation is inadequate. Before that, I want to talk about who's eligible for benefits and how those benefits can be claimed. If you are an employee of a company and are injured on the job, most likely you're entitled to workers' compensation benefits. But you should be aware that state laws often exempt some types of employers from coverage. For example, some states don't require companies with less than 5 employees to purchase workers' compensation insurance. That could be the case with your father's tool and die shop. Other states exempt farm workers, domestic help, and other kinds of workers from coverage. You need to check with your state's Department of Labor to be sure that you're covered. If you fall within the 90% of American workers who are covered, you will be entitled to benefits even if the injury you suffer at work is a result of your own carelessness. You won't receive benefits, however, if you deliberately injure yourself or if your injury was caused by your drunkenness or by drugs.
What do I have to do to claim my benefits?
Just as with filing a sexual harassment or discrimination claim with the EEOC, you must act quickly or you may lose your right to workers' compensation benefits. Your first step is to immediately notify your employer of the injury. Then you should file a claim with the agency that manages the program in your state. Your local Department of Labor can direct you to the right place. Your employer can contest your claim, especially if there's cause to believe that you were actually injured elsewhere and not while working. If this happens, there'll be a hearing at which all parties will be able to state their cases. Whether or not a hearing is held, if the agency decides that you qualify for benefits, it will award you an amount up to the legally established limit for your particular job description and kind of injury. If you aren't satisfied with the agency's determination, you can undertake an appeal within the Workers' Compensation Commission, so long as the appeal is filed within a certain number of days after the initial ruling. If you're still unhappy with the Commission's determination, you may be able to file a second appeal with the state court. An attorney usually isn't necessary unless you decide to appeal the agency's decision to a court. I think you'll find, though, that if your injury is quite serious, it makes sense to hire an attorney whose specialty is workman's compensation. I mentioned earlier that there are exceptions to the rule that a worker can't sue an employer for work-related injuries. If your benefits under workers' compensation are inadequate, you should consult an attorney to learn whether you may be able to receive additional compensation. Obviously, if you fit within an exemption and aren't covered by workers' compensation, you can sue your employer for compensation, or you can sue to draw benefits from your state's auxiliary fund. Which alternative is better will depend on the particulars of your case. Your attorney will advise you.
I work for a manufacturer. What are my rights if I'm injured by a product made by my employer?
Depending on the circumstances, you may choose to sue. For example, if the company you work for manufactured chairs and your injury was caused when one of those chairs collapsed, you'd be able to sue your employer in a products liability case just as you would be able to sue any other manufacturer whose faulty product harms you.
If workers' compensation protects my employer and fellow employees from lawsuits over an injury, who can I sue if I'm hurt?
Even though workers' compensation generally protects your employer and fellow employees from lawsuits over your injury, you can sue other people who might have caused the injury. For example, imagine that you're a receiving clerk and a delivery person carelessly dropped his packages on your foot and a bone is broken. You'd either be eligible for workman compensation benefits, or you could sue the delivery person and, in some instances, his employer. In a case like this, it may be possible to receive both your workers' compensation benefits and sue for damages. If you do that, most courts will only let you keep the amount of a jury award that exceeds what you received through workers' comp. In other words, if a jury awarded you $10,000 for your injuries, but you had already received $3,000 from workers' comp, you could collect only $7,000 of the jury award. You are not going to be able to collect twice for the same injury. Again, if you think you might want to pursue a lawsuit, you should consult an attorney.
If you don't work for the federal, state, or local governments, if you're not covered by a union's collective bargaining agreement, or if you're not working under a contract for a specified term, you're considered an employee at will. An at-will employee generally has less protection from being fired than other workers covered by employment agreements.
While it is true that an employer can legally fire an at-will employee for virtually any reason, or even for no reason at all, there are 5 main exceptions. The most important exception is that the dismissal cannot be the result of discrimination on the basis of race, color, national origin, sex, religious beliefs, age, or physical or mental disability. The second exception allows you to sue for wrongful discharge if the firing violated terms of a private employment contract. For example, the contract may ensure your employment for a period of 4 years. If you are fired without good cause before that time, you are entitled to the salary and benefits you would have received if you had not been terminated. Exception number 3 states that an at-will employee cannot be fired for filing a sexual harassment or unlawful discrimination claim or for complaining about dangerous working conditions. Fourth, you can collect damages if you were fired because of refusing to do something that would be illegal. And finally, the courts have recently begun to protect employees who have worked faithfully for their company for many, many years. Usually the length and quality of employment won't matter unless, as we've said, you're protected by a collective bargaining agreement or employment contract. However, some courts have extended protection even in the absence of such contracts, especially when a firing deprives a worker of eligibility to receive pension benefits. If you are employed by a federal, state, or local government, you receive the same basic protections as the at-will employee. In addition, you can only be fired for what's known as just cause. Typical examples of just cause would be excessive absenteeism or insubordination. Likewise, if you are covered by a union's collective bargaining agreement, you also have all the rights of an at-will employee. And you have an added bonus. You can only be fired according to the terms of your collective bargaining agreement.
Do I have any rights if I'm fired or laid off?
If you are ever fired and feel that your termination was unlawful, you should be sure to consult a lawyer right away. If you don't do this soon after termination, you may lose many of your rights. You may also want to file a complaint with the Equal Opportunity Employment Commission. If you are a member of a union, talk to your representatives. They will be the most familiar with the rights and benefits under your collective bargaining agreement. In addition, the union is likely to know the procedures that you will need to follow in order to contest your firing and assist you with your case. If you sue your employer for wrongful termination and win, your judgment would normally include your salary and benefits from the date of your termination. You may be entitled to other damages as well.
What if my termination was lawful? Do I have any recourse under the law?
As long as you weren't fired for misconduct, you'll most likely be eligible for unemployment insurance benefits. The amount you receive in unemployment compensation will depend on how long you worked at the company and how much money you earned. You cannot receive unemployment benefits if you were self-employed or if you quit your job of your own accord, though many states will allow you to collect benefits if you can show that you quit for a good cause. Examples of good cause might be having to quit to care for a sick family member, or because of extremely bad working conditions, or because your employer basically forced you out. Your state employment security agency will be able to tell you if you qualify for coverage. To apply for benefits, go to your state unemployment office. You'll need copies of previous pay slips and your Social Security card. In order to remain eligible for benefits, you must continue to look for a job. This usually means that you must at the very least check the job list at the unemployment office on a weekly basis and apply for jobs in the same line of work. You can usually reject a job offer and remain eligible for benefits if the job isn't suitable work, considering your education, experience, and skill level. So a white-collar worker generally doesn't have to accept a job offer from the local fast food restaurant. Don't forget that your unemployment benefits are for a set number of months, so you can't be choosy for too long. At some point, you may have to accept a somewhat lower position or risk losing your unemployment benefits or having them run out.
I was laid off when my company plant in Pennsylvania closed down. I'm planning to move to Maryland, where I think the job prospects are stronger. Can I collect unemployment benefits in Maryland even though my last job was in Pennsylvania?
Yes, you may. Every state participates in the Interstate Reciprocal Benefit Payment Plan. This plan allows you to collect unemployment benefits even if you leave the state in which your last job was located. The amount of benefits you receive will be based on Pennsylvania law, but you will have to register for work in Maryland and follow Maryland's law for reporting to the unemployment office.
As you can see from all that we've discussed, the laws that govern employment, hiring, and firing can be pretty complicated. And if you do have a problem, the deadlines for taking action are very short and strict. As Judge Wapner has stressed throughout this discussion, employment law is one area where professional help is essential. The general information provided in this talk is not a substitute for legal advice from a lawyer. For specific advice based on your individual circumstances, see the lawyer of your choice. You may want to listen to Judge Wapner's talk entitled, You and Your Lawyer, for assistance in selecting and working with an attorney.